Well, I'll kick it off if you want, Jose Antonio. Welcome to World Arbitration Update, Day 4. This is, I guess, our fourth panel today. It's been really an exciting week. As folks know, we've had over 19 panels planned for this week on an array of topics. And it's been a real pleasure as co-chair of World Arbitration Update to see the level of enthusiasm and the fantastic support we've been given. And we've like to thank in particular our sponsors. We've had a very active group of firms and entities who've sponsored as well as provided incredible support to World Arbitration Update this weekend. So hearty and heartfelt thanks to all of those folks. I want to introduce, and he'll be on the panel today, my co-chair of World Arbitration Update, Dr. Jose Antonio Rivas, who is the one of the founding partners of Xtrategy LLP, who's not only a sponsor, but one of the key organizers of the week. We certainly would not have been able to put this conference together without the incredible hard work by the Xtrategy team of Anna and Maria Lucia, who I'm sure you've seen their emails coming across your desks for the last couple of weeks. So thanks to them for their hard work, and they've really done a fantastic job of herding all the arbitration cats and getting us all moving in the right direction. So thank you to the Xtrategy team. One of the key objectives of World Arbitration Update is, of course, to provide an update. It's in the title, and to give the arbitration community a sense of some of the new developments that are rapidly occurring in our world, and to give an opportunity from folks from all different corners of the world to share their expertise and this growing body of knowledge. And that's really the second element and key objective of World Arbitration Update, is to fully reflect the incredible diversity of the international arbitration community. Some people mistake international arbitration as only being situated in major centers like New York or Paris or London or Hong Kong, etc. But international arbitration is much wider, has a much wider community than simply the big cities. We've had panels this week focusing on sub-Saharan Africa and MENA and Latin America, and one of our panels yesterday was in Singapore. There really is an incredible wealth of knowledge and skill and experience out there, and that's one of the purposes of World Arbitration Update, is to better ventilate that, to expose, in a sense, and provide a forum for the wide group of really interesting people who've got a lot to add and to contribute in the international arbitration world. So it's been a real pleasure working with all of our speakers and moderators and organizing these panels this year. It's really been great, and so thank you to everybody for your contribution. Today's panel, and I'll give you its name now, is Investment Arbitration and Journalism. And we've got a really exciting group here to talk about those topics. It's something that we thought was a very important, but definitely under discussed element of the certainly the international arbitration world, but in particular in investment arbitration. There has grown over the years an excellent community reporting on arbitration and investment arbitration, and we thought it would be great to plumb the depths a little bit on that topic. I'll say no more because we have a great panel coming up, and it's my pleasure to introduce our moderator as well. You'll see Mallory Silberman is here today to carry the moderator duties. Mallory is at let me just at Arnold Porter and is a partner there, and has acted in dozens of investment arbitrations. She's represented both investors and respondents, and she gave us this nice figure that she's represented nearly 8% of the countries in the world, and that's an impressive figure. So I know Arnold Porter has done some great stateside work. She's also been part of the one of the state delegations involved in the ICSID rules amendment process, and we've got a great panel tomorrow, which Mallory's participating on as well, on the ICSID rules amendment process. There's a lot of interesting new developments, so if folks are around tomorrow, I'd recommend you attending that. That's noon Eastern Standard Time. And actually, we're doing that in person at Arnold Porter in Washington, D.C. So those of you who have not yet registered for that, please do so. And thanks to Mallory for organizing that. It'll be a great session as well. So in addition to her incredible council work, Mallory's served as chair of the International Dispute Resolution Committee of the DC Bar, and that's certainly no mean task. And she's done a great job for a number of years there. And of course, she's been an adjunct professor at Georgetown University Law Center since 2012, I believe. So Mallory's clearly a very experienced practitioner in this field, made great contributions on other fronts as well. And I just wanted to thank Mallory for helping us put this panel together. And I'll pass on the microphone to Mallory, and we'll get going. Really looking forward to this discussion.
Thank you, Ian, for that very, very kind introduction and for the opportunity to be here. Good afternoon, good evening, good morning to everyone who is tuning in. I, like Ian, am very excited for this panel, which is one that Jose Antonio and I have been thinking about for quite a while. The idea came to us as we were watching a discussion about transparency, and we realized that in many of these conferences, you hear from practitioners, from arbitrators, from party representatives, but not often from journalists, from the media, from the other side of the discussion. So today what we wanted to do was bring together not just the usual suspects, but also some of the constituents from the journalism world to discuss this important topic of investment arbitration and journalism. If you've been to any of the other WOW sessions, you know that we typically start with the update, the presentation, but we need to change things up today because our presenter unfortunately couldn't be here. So we're going to make this a dynamic conversation among all of our panelists. We encourage you to reach out with questions in the chat. But first, I will turn things over to our panelists to get the discussion going. So let me just introduce them quickly. Caroline Simson is the Senior International Arbitration Reporter for Law 360, where she writes stories, features, and analyses on all of the latest subjects in international arbitration. And as you may know, Law 360 is a subscription-based newswire that publishes 5 times a week. Remi de Maistre is an international lawyer and the CEO and co-founder of Mundi, which is a relatively new, within the past couple of years, platform that combines international arbitration expertise with artificial intelligence. And the goal, as the 80,000 monthly users of Mundi have seen, is to sort of democratize access to information on international arbitration. In a prior life, in addition to the work that he is doing now, Remi also was an advisor to states as they appeared before international courts and tribunals. Last but not least, we have José Antonio Rivas, whom Ian introduced a bit earlier and who you already may know because he is one of the co-founders of World Arbitration Update. In addition to that hat, José Antonio has extensive experience in international arbitration as the founding partner of the firm Xtrategy, as counsel, as arbitrator, as former legal counsel at ICSID, and as former lead negotiator of investment treaties for the Republic of Colombia. So we are going to hear from everyone today. As I mentioned, we would like to keep this dynamic after we give the speakers a chance to make some opening remarks. And Caroline, I think I will start with you. So as a journalist who specializes in international arbitration, what do you view your job to be?
Thanks, Mallory. Hello to everyone, and thanks for joining our panel. I view my job to be reporting the developments that our readers will find most interesting to them. Since most of our readers are lawyers, I usually try to tailor my coverage to items that I think will help them to do their jobs. So in some ways, I consider my job to be a little bit different than, say, a reporter or GAR. While Law 360 does focus quite a bit on investment arbitration, arbitration-related developments here in the United States also comprise a big part of our coverage. So, I mean, explaining a ruling either by a court or a tribunal with some expert commentary, especially as something novel has been decided, is what I would say is my sort of bread and butter. But often my coverage goes beyond that as well, especially when it comes to investment arbitration. A good example of that was the Rockhopper Award that just came out recently. I mean, even though there wasn't much there for lawyers, because the award, as far as I know, has not been made public, and the details of the tribunal's reasoning are still unknown, there was a lot to be said with respect to the effect that it would have on the future of investment arbitration. And that was particularly since it was such a closely watched case by NGOs, many of which considered it like a poster child for the types of claims that should be banned. So for that reason too, I thought it was particularly important for a reporter with knowledge of international arbitration to write the story, because far too often I see stories about investment arbitration that are written with a clear anti-ISDS bias. What was surprising to me about the Rockhopper Award was that it actually didn't get that much attention from like the international media. There was some coverage in Europe, but not a ton. I thought that was a little bit surprising. That may have been because there was only a press release and no award, but it's a little bit tricky to predict what cases are going to get coverage and what aren't. There was a recent case that involving South Korea and Lone Star that got quite a bit of coverage of Asia. And here in the United States, I'm expecting the TC Energy case, which has to do with the Keystone Pipeline, to get quite a bit of coverage. I don't necessarily see it as my job to provide like a rebuttal to the anti-ISDS stories we see in certain publications. And actually, I often look to places like Twitter to find sources that I know will present that side of it. But I do see it as my job to be a bit more open-minded in my coverage and to try to accurately present both sides of the debate. In that way, maybe journalists like myself who try to present an in-depth explanation of a complex topic so that even people off the street can understand it, can help to counterbalance the Twitter masses and bloggers who really are, I mean, let's face it, they're accountable to no one. I mean, I might be a little naive, or I'm not even sure if that's the right word, maybe hopelessly optimistic, but I think readers have an obligation to question whether writers have an agenda in mind and to not just blindly accept something because it's been written on the internet by someone. I mean, I know it's a little bit corny, this expression, my mother had an expression, but it really stuck with me, which was consider the source. And I would hope that journalists like myself could hope to assuage the fears of those who think that more coverage of investment treaty cases could mean that the anti-ISDS cries will continue growing. Although, to be honest, I'm not sure that the details really matter to the most strident of those critics. I would say it is a somewhat intimidating area to cover because it took really a year or two before I was able to confidently write about investment arbitration. I also think it's important for reporters who cover stories about arbitration to be familiar with the subject matter. I mean, that's true not only so the reporter can parse through dense language typically contained in awards like fair and equitable treatment and minimum standard of treatment to get at what the tribunal really decided, but also because with awards issued in languages other than English, it can be tricky for inexperienced reporters to navigate through the parties' different interpretations. And that's my presentation.
Thank you, Caroline. How did you get into this field, and what did you do during that first year or two as you were trying to familiarize yourself with the topic?
Well, it's not a great story, but I got into it kind of by accident because they needed someone to cover it. And we were just launching the International Arbitration Wire. So they asked me and I said, sure. And it was like being thrown into the deep end of a pool and not knowing how to swim. So, I mean, I tried to call as many lawyers as I could, you know, and just talk and just like, not even on the record, just explain to me like what you do for a living and how these claims work and stuff like that. And yeah, so I mean, it's just talking to a lot of people, reading a lot of documents, just trying to make sense of everything.
I'm sure over the course of that process, people told you what they wished journalists knew about the practice of investment arbitration. Is there anything that you wish the international arbitration community knew about the practice of journalism?
Well, yeah, I mean, I wish they knew that I mean, a big part of my job is trying to get hold of documents. And I know that there's a lot of confidentiality considerations that go into whether or not somebody can release something like that. But I just wish there would be like equal coverage, you know, like if you're going to give it to one publication, maybe reach out to the other publication and see if they can, if they're going to, if they want to do something with it too. You know, it's just equality of arms, I think is what I would love.
Jean-Remy, let's turn to you. So Caroline has given us the perspective of a journalist who is specialized in investment arbitration, but I know you had wanted to speak about what you've referred to as the more general journalist. Can you tell us about that?
Yes, sure, Mallory. And first, thank you to everyone for the invitation and for organizing this panel. Indeed, I wanted to address, because when we had the preparatory call, I made a remark about journalists, and I realized after that I just wanted to talk about generalists, because there is, of course, a big difference between specialized journalists who know about the legal issues and who are addressing lawyers like Caroline, and more generalist people who do not know anything about ISDS. Just hear of some cases sometimes and will report to the public. And indeed, you're totally right, Caroline, it's very complicated to predict which case will get coverage in general newspaper. Like almost 2 years ago, there was a case against France about a very typical case. It was a mine in a French Guiana, and the government decided to stop the exploitation of the mine for environmental reasons. And a Russian investor attacked France and required several dozens of billions of damages. I thought this would be gold for journalists to talk about something, even for the government, you know, to say, look, we are protecting the environment. And we discussed with several journalists in France who should be interested by this topic. And almost no one reported about the case. They found it very technical. They were not sure to understand if all of that was totally real, and they didn't talk of it. And just a few days ago, maybe you've heard about this new case. It's Benabderrahman versus Qatar. It's a French Algerian citizen who is attacking the state of Qatar for some, okay, without entering into the details, but a French newspaper decided that they love this case and they started to report about it, also because it is linked with probably the World Cup that is coming soon. And so I was very surprised that this case will get coverage or not. So the fact that we don't know which case will be covered or not, and it's very complicated to predict how journalists will react and report about the case. It means that the bridge between the public and investment arbitration is not really existing, and so nobody really can have an understanding of the system. And you know, I felt it when we started the company, Mundi, we started it on investment arbitration. And so when I hired IT developers, designers, telling them, okay, come to build this startup with us, we will make investment arbitration easily accessible to everyone. And I believe it's a good thing to do. people were like, oh, but is it not a system just made to protect some bad investors' interest around the world? And people, most of the time, just have a very biased image. And I think this is a problem because we can criticize the system, especially investment arbitration, for sure. But I believe that the international legal system, even broader, is something very important, something that we need to value and to improve and to democratize. So people all over the world will want to participate in improving it, will want to protect it, and we can progressively have a kind of almost a global rule of law at a point. So that's why we at Mundi we like to describe what we do as a democratization of the access of international law and international arbitration. And one way to do it, for instance, for investment arbitration, we built some wiki notes. Maybe you've heard about this project. We collaborated with the community to build almost 300 wiki notes on investment arbitration concept. And the text of this note is freely accessible. You don't need to have a subscription to read them. And so I just checked to prepare our conversation. I've seen that we have currently 30,000 people every month reading this wiki note, and more than 80% of them are accessing the free version of the note. So just probably a lot of legal students all over the world, but also people looking for information on investment arbitration. So I think we have to do more and more of that to build the bridge between the general people and journalists and investment arbitration.
Jean-Remi, I want to press you on something you just said, which is that we have to do more, perhaps more to educate journalists, more to provide information about how these cases actually function. I always wonder who the we is that actually can do that. And I raise this because I went to public communications school. I studied public relations and journalism, and I would love to be having these discussions with people, but I think investment arbitration has a real PR problem, and I don't know who is the right messenger for some of these messages, because over the course of the past couple of years, there has been a lot of discussion on Twitter, but also from various other sources saying that the experts in investment arbitration are a part of the problem. You know, there's a cabal of counsel and arbitrators who do cases over and over again. And once you have had that mud thrown in your direction, it's a bit difficult to go out and say in defense of the system, well, I think there are certain areas to be fixed, but I don't really think this is a valid concern for the following reasons. Who is actually well-placed to be doing that? Who's the we?
So it's a good question. I know it's always tricky for a lawyer because you can't really speak of your case, especially if you lost it. It's always complicated, or even if you won. And indeed, there is this reputation. But I think lawyers, counsel could do it more. First, because there is this idea that, okay, we should not do it. We should, to be happy, let's stay hidden. And that's how I've been taught when I was a counsel as well, to never really, to never talk to journalists because you don't know what will happen. So counsel can play a role, but I believe those who can really play the bigger role are academics. I've always seen academics are the kind of specialized journalists who are here to understand what is happening in the legal world from a neutral point of view, and who have to write books, to talk to journalists, to explain to the rest of the population what's happening. So there are some kind of guardians who have to analyze, but also to build this connection with the rest of the population. So I think they should speak more, explain the value of it, because when you discuss with someone the value of investment arbitration and you have like a real debate, people are not so easily convinced that it's always bad. And we should have more debate, and academics can play this role, I believe. Yeah.
one other thought that has occurred to me, just having seen something of both sides of, this debate or this discussion, is that people seem to forget the ethical or professional obligations that others have. So when there is a lot of criticism or there are allegations that attorneys are only in it for the money, people aren't bearing in mind all of the work and blood, sweat, and tears that goes into these cases and the ethical and professional obligations that attorneys have. And similarly, I'm not sure that the people who are fearful of conversations with journalists really understand the professional integrity of journalism and the ethical standards that apply in that context as well. Jose Antonio, I want to turn to you in a second, but Caroline, do you have any comments on that last piece?
Yeah, I mean, actually, Mallory, I wanted to ask you if you've had bad experiences talking to journalists who are very dismissive of ISDS and what they had to say about that. Because I mean, just to sort of expand on that a little bit, I mean, I think that journalists have an obligation to approach everything from, without an agenda. So if you're already coming in with something of an agenda, that's not really what you're supposed to be doing.
So I personally haven't had that experience. In going through old, very, very old coverage of investment arbitration, you see some of the skepticism of the system. It makes sense. It was a brand new system that people weren't familiar with, so they certainly had questions about it. I think what scares me more is the Twitterverse, people taking sound bites out of context and creating clickbait. And then all of a sudden that becomes the story. It's the headline. It's something that could show up in a listicle about investment arbitration, and it's not actually the substance. And unfortunately, these days, that tends to get as much attention from, our hive mind as a world as real, true, actual journalism. And I don't know how to combat that.
Yeah, I mean, I don't know if this makes you feel any better, but I don't think that's just happening to international arbitration. I mean, I think that's pretty much every area of the news these days. And it really, that's like one of the things that irritates me the most about being a journalist, is just having to wade through the Twitterverse to get to actually what's going on.
Jose Antonio, I want to turn to you. So we have discussed the perspective of specialized journalists, the generalist journalist. What about the regional journalist or regional coverage? I mentioned a few minutes ago the articles that I had seen, which were mainly from the US. How are investment arbitrations covered in other countries? You're muted.
Thank you. I don't have the cup that says turn on your mic, but I have to get it. I know that some of you might have it. I want to say that the part of the reason to put this panel on was in a way inspired by some of the regional or national coverage by local newspapers or national newspapers of investment arbitrations. I mean, in the 2000s, investment arbitration was really not really a national or international newsworthy type of theme. That was more kind of WTO, which was at the time more sexy. Now the sexy part is investment arbitration, and perhaps too sexy. The issue here is I think that basically when one reads newspapers and how the coverage takes place, it really sounds like a football match. That's how or like a football match or like a soccer match, however you want to call it. It has that sense of patriotism that is very difficult to get away there's no effort to go a little bit deeper and understanding the issues. And you asked a few minutes ago what could be done, and I will get to that as well. But the very minimum thing that people should do is looking into, try to understand the issues and try to go through the complexity of the issues, and then translate that, and that actually happens or needs to happen sometimes. Translate from the award and the outcome of the award into, literally, sometimes it's in English, they have to translate into their own language, but also figuratively translate into basic common sense wording that people will understand, and that is an art. I have so much respect for the journalists that do it, but unless that effort is put there, it is very easy to fall into the trap of preconceptions. And I wanted to show you a couple of examples. So let me put some slides, if I may, very briefly. You see. Okay, I think that I know that. So basically, I wanted to make a full sort of disclosure or caveat that none of the matters that are mentioned here are supposed to be interpreted in a way to criticize either the investor sides or the state side. But I just think that it's important to be very concrete, not talk about the whole state or the investor, but to see how the press has covered it. And it's more an analysis of what I've seen happening in the press than an analysis of the merits or an analysis of anything else, which I because of this panel I am not dealing with. That's the first part. Now, if one moves a little bit further, sometimes what I sense is that there's this sort of disconnect from the time that the award is rendered and the time that the message gets through to the public. In Spanish, we say there's teléfono roto, like the line is the phone is faltered or doesn't work because the end of the message doesn't get through, and that's part of the problem. And I love this graph when I was able to get it, because at the end people don't get it, and then we fall into traps such as some of the cases, like in El Espectador, which is a newspaper in Colombia, and it is actually a very serious newspaper. The headline was "Colombia was spared from paying," etc. And it is true. It did not have to pay. So in a way, it's accurate. But at the same time, if you interpret that, it sounds more like well, it almost lost. And in some of these cases, it was very, very far from losing. So that's on the one side part of it. And the issues, for instance, of nationality, or the issues of both the issues of nationality or other issues are not necessarily discussed. And of course, you do not want to turn a newspapers into a specialized journal, but at the same time, some things should be included there. Now, those are the cases that I think deserve some anecdotal reference, but those are winning cases. And what happens in Ecuador, something similar happens. I mean, even in cases where they lost, what I see sometimes is that there is a difference between specialized legal and economics news, which tend to be a little bit more accurate than simply national news or general news. I mean, there seems to be a greater in-depth analysis even from headlines to headlines. The same thing with Bolivia, and then what happens with negative outcomes, and this is in many ways what sort of inspired my thinking about this panel. There's one press release, you have the date there, where the state, in particular Colombia, lost on liability. The damages have not been assessed by the tribunal yet, and in that case, it's the Ecooro versus Colombia case. There was a press release which went out on a Thursday by the agency in charge of defending Colombia, and then by Friday the press release was taken offline, in part because the headline was basically Colombia achieves important international decision to protect the Páramo de Santurbán, which is a protected area. The first 4 paragraphs basically indicated how that achievement had been attained, and then the 5th paragraph has very, not, I mean, to my taste, there's a responsibility. So to some extent, there's accuracy, but at the same time, the language says basically, and this is a translation, a free translation, although in an unusual manner, the litigation continues after this decision, as the tribunal found that Colombia is responsible for not applying the fair and equitable treatment correctly. You know, the proceedings continue. And the bottom line, when I first saw it, was it's not necessarily fully transparent, in the sense that the headline is not necessarily accurate. There's a reference to responsibility, but of course, you know, I understand that they must have seen that it was not, that it was, and here's the sort of like the version in Spanish, but ultimately the issue is it was not necessarily fully transparent, and I believe that most of the investment arbitration awards give an opportunity to understand what went on. In this case, in particular, the opportunity was in part in the separate opinion, and therefore my invitation is for parties, including, you know, parties who report on their own cases, press releases, and also local press, to, you know, first be accurate and transparent as to what really happened, because otherwise it could backfire. In any country in Latin America, yes, perhaps not everyone's bilingual, but you put something out there, and a few hours later, those who read English will see it, and it's a nightmare then, in terms of public affairs. So my rule of thumb is be transparent, say what was the actual outcome, and then explain what was the other perspective. And in this particular case, the other perspective was provided in the separate opinion, and a carve out, etc. I mean, that's sort of the perspective. Finally, the challenge, and I insist, you know, journalists, you know, good journalists are really masterful in simplifying complex matters, and that's how and why I have so much admiration for them. But there should be an ability to simplify. The last comment that I wanted to emphasize is the importance to go and have a greater communication between the arbitration community and the experts and the press. I'm not entirely sure that I share that you know, that suggestion of Jean-Remi as to perhaps the academics could do the work. I have sort of a greater trust, for instance, in the editors of Mundi, or in the editors of competing outlets, because they have to deal with the issues and explain them. or in exercises like the ones that we're trying to do in WOW to make things accessible to the broader public. I'm not sure that the academics would be able to simply, unless they do both. Some of them do both. Some of them are arbitrators, academics, and they also are journalists. So that's sort of my take on it.
Thank you, Jose Antonio. Do you have any suggestions for journalists in terms of how to simplify or how to even find the right words to describe something that aren't embedded with disparate positions of the parties? So let me give you an example. Something you frequently see in briefs is an event that is described by a claimant as a failure by the government to issue a license, and then described by the government as the rejection of a license application. Is there a neutral form there? How do journalists go about reconciling these different positions, the fact that the parties may still be disputing these issues? How can they convey accurate information in a simple way without making a judgment call as to which side might be right?
Well, I'm going to take sort of the experience of putting, sort of thinking about the World Arbitration Update as a forum with a format that will allow people to come into sometimes complex themes and acquire in, say, 10 minutes a baseline. One of the key of our formats is thinking that at the beginning of each panel there should be a presenter, and sometimes, and we've, for the preparation of the whole forum, we've sort of grappled with the idea of what does the presenter do, and sometimes you get sort of outlines or presentations where there is where there are editorial comments, and that's what I think that one should try to avoid. In the example that you gave, at least from my perspective, I would say that the rejection language is way more neutral than the failure language, because there's a, objectively you can say, well, they didn't, did they get it or not, and therefore the failure in itself is there's at least preliminarily there may be a lot of charged language in terms of relativism and subjectivism. They did not get it, it's a failure, but that's sort of my approximation to it. So when I read an outline, or when I look into a description of an issue, looking for neutrality is always important, which is not the job of counsel. Counsel's jobs is completely different. I mean, we are there to explain the facts in such a way that they will be easily understood, but there's a narrative that is being constructed. But I believe that in terms of reporting, my suggestion is trying to find the neutral language that will allow the reader to understand it without making a judgment call. It's very difficult, because sometimes if there's no spice, people don't read it. So and that's as far as I can say. In terms of collaboration, I don't think that it would be fair to anyone, and I don't think that it's fair to journalists that they're simply handed briefs or handed awards. There should be a greater commitment by the international community and by the arbitration community to try to explain those outcomes with them. And I know some colleagues do it. I've done it in just a few occasions, but I think that is part of the game. And of course, journalists sometimes go both parties, and that's part of journalism. But I think that there's a greater responsibility also in the international community, because then we complain, oh, the whole arbitration system is under attack, but there needs to be that translation so that the message doesn't get with a question mark or completely in sort of Martian terms at the end of the day.
Don Remi, how do you deal with that? You mentioned earlier the wiki notes on Use Mundi. How do you make sure you are conveying information in an accurate way that is not too spicy, just to actually give readers the end result or information? You're muted as well.
On your first example, I'm not sure journalists, and I mean here generalist journalists, should really comment during the proceedings. I mean, the fact to know that there is this case and to inform the public is one thing. And I think, Mallory, you mentioned this during your presentation at ICA. If during the proceedings, journalists have access to everything and comment on everything, it is making the case more complicated. It creates pressure, and we have to be conscious that not all journalists will play fair and will be neutral. A lot of them will be voluntarily or not biased, also manipulated by either the investor or the states to achieve a specific interest. So it's also very complicated and important to preserve the tribunal from such external pressures. I've been able to see how in some cases parties were using the newspaper to try to influence the decision of the tribunal, or just after to have an effect on the other proceedings. And because we are in front of international cases, often it will be approached differently from a country to another. When only European companies were attacking foreign countries, nobody in Europe never complained about investment arbitration. When states started to be attacked, it became different. So it's very complicated for anyone to not be biased. And now for the wiki notes, it was indeed one of our main challenges because we wanted to make it neutral. So we had this conversation with our editorial team. Is it possible to be neutral, and how to achieve that? So we decided to do it through two ways. First, we built the note with a collaborative approach. So I've told you we have almost 300 notes. I think we have something like 200 authors. So we have contacted people all over the world. We've created some automatic email to an algorithm to identify all the best experts in investment arbitration all over the world, because we really wanted to have this broad scope of writers. We've contacted them, matched them with a specific topics, and then we created a very strong editorial process. So we had one editor dedicated to this note, and we had like 10 editors in total. And then we had a second editor who would review the note again to make sure we had different views who could express themselves, and with this goal in mind of keeping the neutrality. Sometimes we had to enter into fight with the authors because it's not always obvious what is neutral or not. But at the end of the day, we could settle most of the difficulties by saying, look, this is your position. We'll just add another paragraph to say there is another position that says this. And if you go to the wiki note, you will see often different paragraphs for different interpretations. And that's the way we could achieve the best that we could. But sometimes we have complaints of people who say, look, it's not neutral. Look at your writer. Maybe that's why the person was not neutral. And we realize that we've let something happen without realizing that it was biased, but we correct in this case as soon as possible. And but here again, it's something quite technical, made not for lawyers or for people who want to really know about the concept. So it's more, it's easier to be neutral than just reporting from a generalist point of view.
Well, continuing on this theme of everything being complicated in this space. Caroline, this will be a long-winded question for you, but I'll start with something that José Antonio said that really resonated with me, which is that sometimes coverage can feel as though it is a soccer or a football match. Or maybe the fear is that the coverage will be shown in that manner. And that's very difficult in the context of any sort of litigation, especially when there is a time lag between the pleadings. So imagine that one team is running down the field, they take a shot, and then the coverage picks up from there. You don't know yet who is going to win, if the shot will be blocked. But there's all sorts of media coverage about this before the other side has its chance to respond, defend. You don't know ultimately what the outcome will be. At the same time, I understand the benefits of live reporting. If you wait until the end of the case, the concern may be that this is no longer newsworthy. So Caroline, here's the question. How do you balance all of those things? Wanting to make sure you get it right, that you don't interfere with the process, and that your story remains newsworthy?
Yeah, well, that's the tricky part, isn't it? I mean, the way that we approach that is, I just always try, whenever I'm reading a brief or seeing one side of it, I always try to take that with a little bit of a grain of salt. And it's tricky, I'll admit. When you have a giant long brief from one side of a dispute, it's really hard to try, especially if you don't have one from the other side. It's really difficult to try and counterbalance that. I mean, the best we can do really is, obviously we do reach out to both sides and we try and get both sides of the story. It doesn't always work out that way, but what I do is I try to make clear that these are strictly allegations. None of this has been proven. This is what they're arguing. And in that way, hopefully, it's clear to the readers that this is something that is still an open debate.
So we have a couple of questions now from the audience. We are welcoming other questions as well, but since Caroline just spoke about some of these, I'll continue with this question from the audience, which is, what are the, challenges before journalists on the issue of reporting investment and commercial arbitration beyond, the tricky pieces you already mentioned?
Yeah, I mean, that's kind of a broad question. I mean, I would say one of the trickiest parts is learning how to do it, which takes it. I mean, and a lot of times when we have reporters coming up who are just starting to write about international arbitration, they'll come to me with questions and they'll want to know how to do something. And unfortunately, the only thing I can tell them is you just have to do it, just do it like a bunch of times, and it'll get easier every time that you do it. So, I mean, other than experience, I mean, the confidentiality angle is always kind of a tricky. I mean, I have little, methods that I've developed over the years to try and flesh out the details if everything is confidential. But that's still a very difficult part of the job. Other than that, I would say, that getting people to talk to you is one of the most important parts of this job, and getting people to talk to you on the record, ideally. And so learning how to do that in a way that people will seek you out and want to talk to you that's definitely one of the trickier parts. It takes a little bit of skill to do that.
José Antonio, Jean-Remy, other thoughts?
Well, I have nothing to add concerning how to do a good job in journalism and to report the news, but I have something to add with respect to the why, the why good reporting and accurate reporting matters, and of course, in those of us that or at least I believe in the system. It's not perfect. It must be improved. It's evolving. It's not that mature, yes, but I also feel sometimes that we forget sometimes that part of that improving or part of that modifying it, even on some of its principles, should go through the process of criticism, and what's the good and the bad, and unless there's transparency when states lose, or when investors lose, those modifications to the system will not be able to be done. Sometimes I feel that for those of the international arbitration community, there's this fear that the whole system will be modified so fundamentally that mistakes are not necessarily being underscored, which I think is important. And for the parties that lose, sometimes states, sometimes investors, there's also sometimes a lack of being upfront and transparent, in the sense that unless you do that, the state itself will not be able to take responsible actions. It being part of the system, or moving for a multilateral court, or staying as it is, etc. But I think that is important for the maturity of the system. I've seen, and just one more comment. I've seen states that are mature whenever some breaches of international or some breaches of investment standards take place. So mature that they have actually negotiated deals or conciliated damages without going through a whole arbitration. And in other cases, other states may not be that mature, and the whole football match analogy is applicable there. It's kind of a patriotic affront to lose a case, which in many ways is and I hate to use this term from a past case, but it's kind of silly. It's kind of silly because in many countries there is a chance for private parties to sue the state or to sue agencies, but when it becomes an issue of the nation state, it becomes sort of a football match or an affront, which doesn't add up. Why could a national from any state be able to sue its own state before national courts, and why would it be an affront for foreign investors to do so? It's simply a right of recourse. And I'll stop there.
John, Remi, other thoughts?
No, just maybe on the challenges. So at Mundi, we're not really doing reporting. We're more trying to get information and deliver it directly. And when it comes to investment arbitration, yes, there are many challenges because, as you said, sometimes information can be complex to analyze. Also, it can be quite dispersed. You have different languages. A lot of information can be collected through actually more enforcement proceedings all over the world. So it requires a very broad network of people who can digest the information. And if you expand to international arbitration, even if it's not really our topic, it becomes even more complicated. So I think we lack today the necessary information systems that can really support the legal system as it is, to make sure everyone has the same level of information and everyone can have the debate at the same level. So that's something that needs to be improved. And I know it's a big challenge for everyone who wants to report on investment arbitration. So yeah, just one thought on this.
Well, there was also sort of an implicit difficulty or challenge that all of you alluded to, which is a limitation imposed by the medium. So we all have been discussing written journalism, and I think there is a lot of difficulty with trying to reduce these very thorny concepts or these hot button issues to writing in an effective way, that will be understood by everyone picking up a newspaper or clicking through articles on their computer. I've always wondered whether it would make sense to tell some of these stories as documentaries as opposed to having them reduced to 500 words in writing. I have no idea how that actually would work in practice, but it might help to liberate writers, producers from some of the difficulties of the written medium. Let's turn to another audience question, which is, what are the privacy confidentiality issues that might arise, if any, while reporting on a live investment case when journalists are reporting what is the best way to be transparent while preserving the privacy and or avoiding the pressure or be biased? Basically, how do you do all the things?
I can just say I believe it's honestly very complicated to avoid the pressure and bias during a live case. Because each party will want to use this as a way to influence either the decision from the tribunal, but also what the public will think of it. And most of the states, at least, they have an agenda. Mallory, you worked in public relations, and so you know how it works. Like a state will should hire a public relation agency when the state has a case in order to try to defend its position globally. And some states are able to do it with a very high level of efficiency. I was telling you the story. So if I take my former counsel hat, and I used to work for an Asian state on the South China Sea issue during many years, and so I was following very closely the award that has been rendered by the tribunal between the Philippines and China. And you might remember how China dealt with the award and the peer strategy that was put in place by the state was very impressive. One of the elements that I remember is that they built a video clip that was broadcasted on Times Square like 10 times per day during 2 or 3 weeks. So it was a huge investment. It was something very part of, it was not the only action, of course, but it was part of a strategy that was directed to other governments, but also to the general public to defend their position and to diminish the value of the award. And I think this is always part of the environment in which tribunal have to render the decisions. We even know some stories where states directly wanted to affect the tribunal. In this case, for instance, the website of the PCA was taken down during the hearing, so it was impossible for anyone to have access to the website and to the info on the case. So I don't think it's really possible to answer. Maybe it's not a very positive question, except for here specialist journalists who will make this real analysis and report on the legal issues of the case.
Is there anything that tribunals or international courts can do to improve the coverage, improve the accuracy of the coverage of their decisions?
I'll take that one. Just let us know when we make a mistake. I mean, every journalist I know is very responsive to making, if we make a mistake, we want to be called out on it. We want to know so that we learn from our mistakes. So, I mean, if there's, I don't think that applies necessarily to, because I'll get, comments from people about how it's implying a certain thing or they don't like my wording. I'm not talking necessarily about stuff like that, but I'm talking about like actual inaccuracies. I mean, that's, I'm very sensitive to something like that.
Did the Global South and Global North pose different challenges on arbitration reporting? It's another audience question.
I don't know. I mean, I think there's equal challenges on both sides of the equator. I mean, it's a little trickier in places like, South America, maybe where I don't have as many contacts. But I mean, I would say there are definitely challenges on both sides, like I said.
There is also a comment, I think it was on your suggestion, Mallory, to report about cases in another format, maybe a documentary format, and someone suggested a podcast episode, 20-minute podcast episode. I actually think it's a very good idea. There are so many cases that are so interesting when you enter into the fact and understand what happened. And I always thought that a good storyteller could do something with these materials, knowing that these are true cases, and I would totally support this idea.
So we only have a couple more minutes before we go into the breakout sessions. I wanted to give everyone a chance to give any final comments or thoughts on this issue of investment arbitration and journalism. Jose Antonio, let's start with you.
Thank you, Mallory. No, my 2-minute sort of take on this is first the importance of transparency, and I'm sort of like talking from more general newspapers and local and national newspapers, which may not be specialized. So the importance of really trying to be loyal to what happened, and in part that really that is somehow fed by the parties, either the investor or the state. So there is I think that there is an ethical responsibility there, which I think that it is common sense to be transparent and accurate, because otherwise at the end of the day, people do get to know what the real result was. So that first, and then the emphasis should be not only in leaving journalists and their efforts completely isolated, because communication involves interacting between them and the other party. So I think that we play a huge role in that communication. At some stage I was thinking by tribunals, but some national courts have the model of press releases. I mention it because it came to my mind, but I'm not proposing it. I'm not necessarily proposing it, because sometimes the press releases only create nightmares for the courts and for the journalists, because sometimes the press releases come before the decision comes out, and then there's no real consistency between the press release and the decision. So I'm not entirely sure that that's a good route. Perhaps press releases after the decision has come out, but not before. That I can say with some confidence. That might be an idea. In addition to the 20-episode or 20-minute episodes in podcasts, which I agree is a good idea, but something that would be useful for them to rely on, not before the decision has come out, because I think that the notion that the decision should be to speak for itself is a very strong one that we get from common law and from U.S. courts.
Jean-Remy, any final thoughts? You're muted.
Just maybe to build on what José Antonio said, that's, for instance, the practice of the International Court of Justice. They do press releases for every step of all the cases. I know for them it's a very delicate exercise to make this press release and to explain what happened in a neutral way. And so it's probably a lot of practice of the diplomaticians who were used to do this in some other kind of UN environment, and so they are able to produce this. So I guess it helps. They've really built a kind of press corner to inform as much as they can on what they do. I believe it's very positive. But you know, when there is an ICJ case, I still read in very famous newspaper like, oh, the ICC said, and they totally confuse the court. So it's I think there is a long way to go to better promote the international legal system, and so who can do it? At the end of the day, I believe we have a shared responsibility to do it. I think that someone has the question about the arbitral center. It's a bit complicated for them because their business is also to sell confidentiality, so it's complicated to report. But if we all play our part, I believe we will make the system better, more easily accessible for everyone.
Caroline, any last thoughts?
Yeah, I just have one brief comment, which is that you know, over the last 6 years I've been reporting on this, I've really developed a respect for the subject area. And I think it's a really important subject area to report on. And because I think that, you know, the unknown is scary to people. And if, you know, the investment arbitration community wants to protect the investment treaty arbitration, I think they need to put everything out there, and don't be afraid to explain, you know, to take the time to explain things to journalists, you know, and don't assume that every journalist is going to be anti-investment arbitration. I mean, this is something that really affects all of us at the end of the day, and it's something that is important, and it's important to get it right too.
Well, thank you, Caroline. Thank you to all of the panelists for this very, very useful discussion about an important issue. I'm going to turn things over now to Maria Lucia so that she can put us into breakout rooms.
Thank you, Mallory. Now I'll send you everybody to the breakout room.